Hi, everyone. Thanks for joining the Privacy and Technology Law section today. We'll give folks a few more minutes to filter in. Awesome. We'll give people another minute to filter in. Thank you for joining us once again. Really excited to kick off this awesome panel discussion on de-identification. All right, we are 3 minutes in. I think it's a good spot to get started. Seems like most people have joined. Thank you all for joining the Privacy and Technology Law section, CLE, focusing on de-identification. We're really excited to have this panel discussion because this is such an important topic that impacts both privacy and security attorneys as well as non-attorneys. And there are not too many deep dives on this topic. I'm really happy to present today an expert panel that spends their day-to-day in this work. These experts will refine our knowledge regarding de-identification techniques and its legal and technical compliance considerations. And I will let the speakers introduce themselves. I'll start off as moderating. My name is Tony Igbinova. I'm the vice chair of the Georgia Bar Privacy and Technology Law section. I'm really happy to put together this CLE and many others that I've done in the past. I'm also an associate at Baker Hostetler, where I focus my practice on privacy governance, ad tech, as well as biometric compliance. And I'll pass it over to Kyle, just because I see you right beneath me on the screen.
Tony, Kyle Gregory. I'm an associate with Baker Hostetler as well, and my practice operates kind of at the intersection of healthcare, technology, and privacy. So de-identification is always top of mind. Well, I will. I guess I'll hot potato it over to Liz.
Hi, everyone. I'm Liz Roberts, and I'm privacy counsel at DuckDuckGo. And so I'm in-house counsel, and my practice encompasses all things privacy, including data governance and general compliance. I'll pass it over to my colleague, Andreas.
Hello, so I'm Andreas Davis. I work with Liz at DuckDuckGo in the privacy engineering team as senior privacy engineer. So I'm working mostly on the technical side of data privacy. My background is in statistics, physics, and computer science. So I'm also excited to be here. And I'll pass it to Tony, maybe. Oh, sorry.
We'll have Krista jump in.
Yeah, Chris. Okay.
Good afternoon, everyone. My name is Krista Marshburn. I work in the Global Privacy Office at McKesson. I'm a senior director there where I manage the data de-identification team. My background is in data analytics and all aspects of healthcare administration. We support our internal businesses at McKesson to in their strategic data initiatives within the organization.
And then I'll wrap up. I'm Eric Bowmans. I am a non-practicing lawyer, but with a focus on helping my clients translate the compliance and governance to actual technical controls, implementing things in cybersecurity, privacy, and such. So looking at it from both how do we actually do it technically and from the legal perspective.
Amazing. Thank you all for the introductions. Really excited to have your knowledge and background. So we'll just jump right into our questions for discussion. Starting off with, what is de-identification at a high level, and what are the goals of de-identification? And Eric, since you wrapped us up there, I'll let you kick us off.
Sure. Yeah. So from a purely technical perspective, right, it is removing whatever protected personally identifying information, whether that's healthcare, whether that's payment information, all those things that we are going to be protecting and talking about throughout today, helping remove that so that what we have left is a data set that we then can feed into analytics, into machine learning, into all the different business use cases that we want to gain, but focusing on how do we remove that PII, that information in a way that then meets the standards for all these different things. When we go in deeper, or is that a good?
I'll let another technical perspective jump in there to either agree or add more to what you had to say, or we can have the legal perspective of what de-identification is and the goals of de-identification.
Well, I'll jump in. So I agree with Eric. It's a way that at McKesson, we enable the businesses to be able to, as I mentioned, support their data initiatives while protecting the personally identifiable information that they manage day to day. We want to make sure that, that the privacy and utility of the data is balanced. Data de-identification is not just one technique. It's a combination of techniques, approaches, algorithms that we utilize to protect patient data in support of the privacy rule.
That's a great point regarding the complexities of it from a technical perspective. You mentioned the different algorithms and the multiple techniques that are involved in the process from a technical perspective. Now, from a legal perspective, what is de-identification and what are these regulatory goals regarding de-identification?
So Tony, I'll jump in there, and the hesitancy comes from when we say de-identification, particularly for the lawyers, which at least if you're like me, have very, very minimal background in statistics and whatnot. So what de-identification means legally will depend on the jurisdiction. It will depend on the industry. It will sometimes just depend on the agreement. It can mean a lot of different things to a lot of different people, kind of highlighting what we mentioned earlier, that it's not a single technique. It's not a single methodology. It describes a goal. And legally, the approach has kind of been how to balance the conflict of you have all these organizations who are now increasingly data-centric, who have, on one hand, the need to protect the privacy of information, whether it's personal or not, and at the same time to use and maximize value of this information they hold. And when all things work right, at least from a legal standpoint, you are able to kind of serve both masters. Or try to, but it is a balancing act, and the definitions kind of depending. It's a good way to tell how old a definition is based on how it's defined. So, and I'm not here to pick on FERPA, but FERPA,
do it.
It really only contemplates the removal of direct identifiers for like FERPA does not apply to information in educational information from educational records where all personally identifiable information has been removed. It does not contemplate any kind of linking. It does not contemplate indirect identifiers. And then you take that to some of the state laws now, which are getting increasingly more sophisticated. Like for Virginia, for example, data that cannot reasonably be linked to an identified or identifiable natural person or a device linked to such person. And so now you're starting to see a little bit more, okay, it's not just direct identifiers, but what information can be linked to a person or a device. And that's kind of reflecting a lot of tracking technology questions. And now increasingly with the latest round of the newest state laws from like Minnesota, for example, means data that cannot be reasonably used to infer information about or otherwise be linked to identified or identify individual. So we're now going another step further. I think we are just getting a little bit more as we're slowly, at least for the lawyers like me who don't have any kind of statistical background, slowly becoming a little bit more educated about that this is a continuum. It's not binary. And kind of appreciating the nuance involved in what it means for something to be de-identified.
Right.
Yeah.
I mean, based on what you said, I have so many questions, but I'll have to save them for when we dive more into the legal perspective. I will highlight how you've done such a great job at letting us know how nuanced this area can be legally. I mean, the FERPA example compared to the current state privacy laws example, and that's a good note regarding telling the age of a law through definitions. I love that. Liz, do you have anything extra to just say from a legal perspective about what data de-identification is, as well as the goals of it overall? And our technical people just wanted to keep in the back of your mind, any thoughts on how, you know, the technical implications kind of conflict or work alongside of the goals of the laws, or maybe it's the same thing?
Thanks, Tony. I stand behind Kyle's definition of it depends for us lawyers. And I'd say one thing that we struggle with generally in law, and if you work at a company with global operations, and even if not, if you're just a US-based company, there's a lot of conflicting regulations. The supervisory authorities often issue conflicting directions. There's conflicting matters in the courts. And so, you know, practically for your client, whether it's one client in-house or several clients at a firm, is how do you deliver practical guidance that they can implement in their organizations to be able to meet all of these conflicting standards and deliver, you know, best practices going forward.
No, that's a great point. Everyone is just dropping gems just regarding implementation and practical advice. I find myself in my day-to-day working with de-identification and trying to give, you know, product councils and product teams practical advice regarding their data use and how to properly apply de-identification. And it's really how this whole CLE came about, because I'm like, wow, you know, I'm a lawyer and I'm not this statistics person. I'm not this technical person, yet I'm working with these tough concepts from a legal perspective, but I have to work with people who don't speak the language of the law. So I'm really excited to dive further into our next phase of this topic, which will be the law and the de-identification techniques. And so when we jump into techniques, it'd be great if we can cover these techniques from the general technical definitions, and then the legal definitions, the legal at a high level, the legal considerations when we talk about these technicalities. And if we could kick, well, and I know we just jumped through this as well, just highlighting our legal considerations here. And I guess that's what we can kick off with is at a high level, because we're going to still dive into these more in detail. But Liz and Kyle, if you just want to give a quick one sentence per, you know, jurisdiction about what the laws generally say about this, like how deep do these laws dive into de-identification?
So I can jump in, at least for the the laws in the United States, the laws tend to focus a lot more on the result than the method. I mean, the two examples that the two like exceptions that kind of readily come to mind are HIPAA with the safeguard, the safe harbor method of de-identification, which requires the removal of 18 identifiers. And then the FERPA example I was picking on earlier. But most of the time, it's results. It's based on the end goal in mind. And is less, which I think is helpful. Is much less prescriptive on how you get there. And that's true of the state of all of the state privacy laws that have a kind of an exception to de-identification or de-identified information. And one like add-on point to note is that just because something is de-identified, and I think we'll talk about this later, doesn't necessarily mean it is outside the scope of some of these laws. It just means it may not be personal information for the purposes of these laws.
Love that.
And so from the international standpoint, you have, you know, the GDPR, which also it's very result driven, where you have anonymization that's referred to and it's thrown around a lot. And often you have to measure it against that GDPR standard of, you know, what is anonymization. But then again, that standard is not defined under the legislation. But anonymous data is, so you look at that definition and then work backwards from there, that, you know, it's data that doesn't relate to an identified or identifiable natural person. And then you have in Canada, you have the PIPEDA, which is the federal Canadian privacy law, and they don't have a specific definition for de-identification, and it doesn't actually distinguish between de-identification and anonymization. They're used interchangeably, and it actually says, strangely, that neither are personal information for the purposes of PIPEDA. It's quite dated in terms of the law. There's actually a bill before the federal legislature right now called Bill C-27 to update it. Confusingly, it would be CPPA for short, which is quite close to California's CCPA. So you've got another fun acronym in there. And then, you know, you have the, although we're talking today mostly about North America and Europe, you also have the global laws like APEC and Latin America, which have deal with anonymization and de-identification, and then they have local variations in the laws there as well.
Love that. Thank you for flagging the APAC regions and also that update regarding Canada and the proposed revisions. So for our technical folks, I'll let you all kick off this conversation. And specifically when we're talking about anonymization, can we just discuss a couple use cases for this technique according to your experience? And how did you implement this technique, or how did you work with teams to implement this technique?
Sure. So maybe I can kick it off. So my perspective is mostly from Europe. Based on the GDPR and related definitions, as Liz said, yeah, the definition of de-identified or anonymized data is mostly result-driven. Notably, there are like 3 criteria that the European Union has. It should not be possible to single out individuals from the data. It should not be possible to link the data to other data sets and then, for example, allow singling out again. And it should not be possible to infer any attribute or information about an individual from such a data set. So in general, any technique that produces such a result is good enough in that sense to produce anonymized or de-identified data. And as you also said before, like the definition or like the techniques that are applied to anonymized data have changed over the years, because like maybe 30, 40 years ago, many organizations, legislators would consider simply de-identified data to be anonymous. So you would, for example, remove direct identifiers like a name or a birth date, zip code, for example, from the data set, and then consider it anonymous. But today that seldomly works because there's just so many, there's so many data sets available, and in general, like you can correlate the data very easily in many cases with other data sets that you have available, especially if the data is being processed by a software system. You can imagine if someone, for example, logs into like a patient information system, enters their information there, and then you might say, okay, I can just de-identify the data, remove the name from it. But if you have, for example, a timestamp or an IP address in there or other indirect identifiers, then there are ways to correlate that with log information, which you might have. And then it's quite easy to re-identify the data in the end, or re-identify the person in the data set, so to say. So most techniques we see these days employ not only a removal or generalization of fields, so like changing of individual data sets or data items in a data set, but rather aggregation. So you have to like combine the data of multiple persons, multiple persons in the data set in order to combine them into a larger whole, and then make it ideally impossible to deduce information about individual persons in there. So we see techniques like k-anonymity and related ones. And of course, the most recent technique, which is from a mathematical standpoint very efficient and very good, is the differential privacy. But that's also a technique which is unfortunately in many cases very hard to apply to data in the real world. So yeah.
No, I think you made a good point about re-identification too, and the indirect identifiers. I don't think we consider that as much as we need to, thinking about, even though you've removed the main data points, is there anything else that could potentially identify a user or a consumer or an employee, depending on what the processing activity is? Any more thoughts from our technical folks regarding use cases for anonymization or working with teams to deploy this?
Yeah, I'll talk about one case where it was actually a healthcare database, but the use case was actually for development purposes, right? We have a very robust healthcare database. It's got all the personally identifying information in it. It's very very difficult to share that. So we actually had to use the noise technique to create a comparable data set that was realistic, in the sense that the outcomes and the procedures all made sense if you were to look at it from a development perspective. And it also was from a volume perspective, so that you could test this system against what the actual production volume would be. And so, the whole process there was, as you see on the screen here, noise-based, and just trying to mix and match the data to the point where those 18 things no longer could uniquely identify any of those records as real, but still have the same complexity and volume of a real healthcare database.
Eric, do you mind expanding a little bit more? Maybe this is me being selfish. Expand a little bit more on the addition of noise to a data set. Yeah,
so it depends on, again, exactly what you're trying to accomplish, the outcome you're trying to seek. And it can absolutely be as simple as taking the true PII, the things that are actually uniquely identifying them, and replacing them with literally noise, right? It could just be random characters that nobody cares about, because we don't care about that from an information perspective. Or it could be just creating fictional data that overlays the real data, so that we randomize people's names, birthdays, all the things that could be personally identifying, so that when you're looking at that data, it's all fake. Any one record is now fake. It no longer represents the original thing, because we've replaced those key things with either true noise or fictional data that we just layered in, all the way including changing up the relationship, so that if there's related records, they no longer relate to their original parent record in that system, so that the whole thing just gets kind of, it's almost like running it through the shredder and then taping it back together, and it still looks like a document, but it no longer is meaningful the way the original document was.
Just add to the comments around noise. One thing that we make sure of is when we're adding in noise, that it's in a controlled manner, so that there's precision there. So if we round up an age, that it's consistent across all records. So if we round up a date, add or subtract days from a date, that is consistent for that particular data element throughout the entire data set. So just wanted to kind of throw that in, that it is a controlled method when we're adding noise.
Throwing that in is perfect because I promise you, if you didn't jump in, my next question to Eric would be, how does this impact data accuracy across other data sets? So that was actually a perfect addition there. Thank you, Krista. And how about Krista? It'd be great if you, well, I have a more of a deep dive on anonymization as it relates to the GDPR. Our legal counterparts, if anyone wants to just jump in on this to add more color regarding anonymization in the GDPR.
So I'll jump in here. I think Andreas actually gave a pretty good overview on the legal side as well about identifiers and singling out. And that's key to GDPR. And I just wanted to expand a bit on what I mentioned earlier about some conflicting information coming from supervisory authorities. And so you tend to have kind of two competing standpoints where you have the France's Data Protection Authority, the CNIL, which it takes an absolutist approach to anonymization and notes that in order for anonymization to be achieved, it must make identification practically impossible. And with so much information and such advanced techniques out there, arguably, can that ever be achieved? And then you have in the UK, the ICO, which suggests a reasonably unlikely standard. And in its guidance provides a practical approach to anonymization where organizations should take into account all the means reasonably likely to be used by yourself or a third party to identify an individual that the information relates to, and taking into account factors like cost and time required to re-identify the data, sensitivity of the data, and the audience to which the data will be released. So you have really different approaches here. And often I think organizations take a look at this and choose, a risk-based approach of how they're going to deal with the anonymization standard in the GDPR perspective.
Right. And the GDPR does present a pretty high standard for anonymization. Well, because as you've highlighted how technology has advanced, it's actually the advancement has actually made that definition more complex to meet because there are avenues in which you can re-identify easily, and just a lot of things to take in consideration for it to be impossible to re-identify individuals. And Kyle, if you want to give us some of the state law perspective, I know you highlighted this earlier regarding Virginia. If you want to add another piece or two.
So, no, fortunately for those in the United States, we've taken much more of a ICO approach, or fortunate depending on your perspective. I guess from a more straightforward approach, we've taken much more of a reasonably capable of being linked. Although we are, as I kind of noted earlier, these definitions are starting to reach towards inferences. So this is changing somewhat. But this is also kind of aligned with HIPAA, which data that is de-identified under HIPAA is in no way, shape, or form normally should be considered anonymized for the purposes of GDPR. It's operating on a very different standard. It's much more comparable to the concept of pseudonymized data. So that can always create problems there. The point that I'd like to flag for these other states, as I mentioned earlier, it doesn't necessarily mean that the information is no longer subject to any legal requirement. Forgetting any contractual obligations that the parties may have with respect to this data, for each of these state laws, there are some obligations with respect to the recipient must adhere to with the receipt of de-identified data. And there are also information governance requirements, like it must be considered under a number of state laws, like Virginia, I want to say Colorado and Connecticut, they must be considered in your risk assessment, for example. Other states are silent. It can be while these state laws we're seeing a lot of overlap in this kind of patchwork of state laws, there are important nuanced differences that can make it difficult when trying to spin up an information governance program that deals with de-identification. And we'll talk a little bit more about the contract obligations, I think, later.
Yep, we sure will. So let's jump back to our technical folks. And Krista, if you'd like to kick us off with pseudonymization, talking about use cases related to it or implementation experience regarding this. Is this commonly used? Do you use this more than other techniques? Is this another technique, as you mentioned earlier, that's done in combination with multiple techniques?
Okay, sure. Yes, pseudonymization is just, one technique that is used in my own work experience. We rarely use pseudonymization. It's really more of the other techniques as far as, rounding, which is would fall under anonymization of de-identification. And many times, I've been hearing, Earth using anonymization and de-identification, but I also want to, make sure that everyone understood that they're used interchangeably sometimes, but they're not the same. Because you want to cut that link when you're talking about anonymization. You want to actually cut that link between an individual and their, and their information. Whereas with de-identification, as Kyle mentioned, the indirect identifiers are still resident within the data set and can be linked, because we don't know, even though we say, or the law says that the data, the de-identified data set should not be relinked to, linked to other or combined with other data sets. We have to make sure, that if in the event someone does, a bad actor potentially, gets access to this data, that if it is linked to other data, that it still remains de-identified. So some of the use cases, though, like in reporting, data analytics, even in data feeds that support, business opportunities with partner organizations. Pseudonymization would be useful, because what we're doing is you're adding in artificial identifiers, within the data set, but and maintaining this separately, because the method behind the pseudonymization method once it's been applied. So it's more of a security type methodology that's being applied when you're using pseudonymization. But of course, the methodology and the data set must remain separate. When you're applying pseudonymization to to data.
Thank you for that. And since there's all this, like the level of re-identification is higher here, if the data is not kept separate, maybe Eric, could you just chime in regarding the use cases for this? What industry do you see leverages this mainly?
Yeah, so it's where you still need a very granular level of accuracy, but you don't want to reveal that underlying identifying information. Like when we talk about the anonymization and we'll talk about aggregation later, that's good for statistical, big trends, things like that, analytics. But here, where you actually need to know, how many orders were at this store for this item, for this, how many things are within this specific bucket, pseudonymization can help you, because you're keeping that PII away from the consumers of the data, but you're still allowing it to be very specific, very granular. And because of that, yeah, you do have that risk of re-identification. I know we talk about blockchain a little bit later, but it's also a good example. A lot of people think that Bitcoin is an anonymous platform that if I give money through it, nobody can trace that back to me, but it's actually a pseudonymous transaction. It's still a unique identifier that's my account. And so over time, if I do things that get that link to other data sets, it can actually reveal my identity. So it's not actually anonymous. It's a pseudonym for my name online. So Bitcoin and blockchain is another example of this that we all think falls in a different category, perhaps, but doesn't.
Wow. Andreas, any additional thoughts on this from a technical perspective?
Yeah, so this was all great.
Also, thank you for answering live questions in the chat. Thank you
Yeah.
for that as well.
Yeah, so I agree with all of that. As Krista said, pseudonymization is mostly like, it can be seen as a security measure, so it reduces the risk of processing sensitive personal data in any software system. It doesn't, it can have benefits depending on the legislation. So for example, in GDPR, It can make some processing of the data possible that wouldn't be possible if you wouldn't pseudonymize the data. So you can basically reduce the risk of re-identifying individuals, and that can again make it possible from a legal standpoint to do some kind of data processing that would otherwise be too risky for the individuals involved. So I think that's really the main benefit. And the very nice thing about pseudonymization is that it like preserves in many cases the coherence of the data. So it doesn't group or aggregate data like you would typically do in anonymization. So it's very easy to work with the pseudonymized data normally. And as Chris has said, often depending on the technique, it's also possible to deep pseudonymize the data again. So you can go back to the original data if you need to. So in that sense, it's a very flexible technique. It's kind of like a partial encryption of the data, you could say. So you remove the personal information or the direct access to that information and can still have all of the structure and all of the information in the data at the same time that you need for your business case, for example. So in my opinion, it's a very maybe undervalued, but also very useful technique in processing personal data.
I want to shake up the conversation with our legal folks. So our technical folks are loving this technique. It's flexible, as you keep the data separate. But for our legal folks, what happens if a team comes to you telling you that a data set is completely de-identified because they pseudonymized the information? However, you haven't validated that the data is truly kept separate. Can you just shed light on some of the legal risks related to that?
So, and recognizing again what my area of expertise is, which is not any kind of statistical analytics. It's a lot of asking follow-up questions. It's diving in deeper. What's the use case? What and that include what is this going to be combined or linked with other data sets? Who is going to receive this data? Are we going to publish this on the website? Are we, giving this to a longtime business partner that we have agreements with already? Just understanding what's the risk profile here, because de-identification in its various forms, it is not, as I said earlier, the risk profile can look very different depending on how it's deployed. So for me, it's a lot of fact finding rather than, validating, oh, well, you're linking it with this quasi identifier and that could create a risk for re-identification. I mean, those are just words I've just thrown together. So, that could be a thing.
Liz, any thoughts?
Yeah, I think that this is an area where lawyers rely a lot on their technical colleagues to, they have the deep knowledge and, we provide the framework, but, it's very helpful to have the technical folks there to explain it to us and really they're the driving force behind being able to say, okay, we've adequately mitigated our risk in this area.
Love it. For our legal folks on the call or even our non-legal stakeholders, ask more questions, And we will look at aggregation next. If we can.
Yeah. So if I could add just one more, there's one component that's missing. We have the risk profiles and everything, but one component that's missing is the, having an expert in de-identification to actually do analysis on the data based on the different techniques that have been applied to ensure that they are appropriate and that the risk of re-identification is low according to, or it's very small in accordance with the HIPAA privacy rule. So that's one thing, that is necessary in order to put the gold stamp on a deliverable before it is shared externally.
Thank you for that piece. Krista, since we have you wrapping up pseudonymization, you might as well start us off with aggregation regarding use cases and just technical considerations for aggregation.
So aggregation in our organization is mostly used within the research area. They are often doing studies where aggregated data, within a certain population is useful in studies, in articles, in like even with genetic information. I know we haven't touched on that either, but it's aggregation will, generalize the data, more. You're generalizing more, and you are, not, I guess, keying in on a specific patient, not keying in on specific patient level data. One thing about aggregation also is you have to be careful, because if you end up with some very small cells of individuals within a data aggregated data set, then there is still the opportunity to identify an individual based on the other data elements that are in that in that aggregated data set.
That's a good flag. And I've actually experienced that in practice, where I've had to tell a team that they cannot leverage aggregation here because the data set is too small. I mean, if you're trying to aggregate an employee data set and it's 2 employees, and you kind of already have a feel for like how employee sentiments already go for each person, the data is not really aggregated in a sense. So that's a good point about considering the size of the data set. For our technical folks, Andreas, Eric, please chime in.
So most of what Krista said, I think it would just echo that, right? It's as you take that data, as you aggregate it, you should lose perspective on the individual data, right? You should be getting to that point where you can't reverse that even with that additional data sets. And just to echo that point too, and it's in the chat as well, the population size though still has to be sufficient. And I think that the reminder too is that if you've gotten that small of a population, then not only is the risk of re-identification high, but so is the statistical value of that data has gone down as well, right? You should not be generalizing on a small population size to a larger anyway. So that even the statistics don't work at that point.
Yeah. That's a great point.
Yeah, I would echo that. So aggregation is something that we use at DuckDuckGo, for example, quite intensely to generate anonymous statistics. And that works really well if you have, as Chris has said, like large data sets, So if you're an internet property, the benefit is that possibly you have millions or hundreds of millions of data points that you can aggregate. So there, this technique works very well. But for small data sets, as you said, Tony, also, it of course can't work because there's not enough statistical information, so that either after aggregating the data, your statistical information is destroyed, or you still have the risk of data leakage. So those are like the main, I would say, in practice. In some cases it's very easy to do aggregation, but in some cases it can also be very challenging, depending on how many attributes, how complex your data is, and how many data points are in your data set. So
it seems like you all have been touching on data utility. So since we've covered anonymization at a high level, we've talked about pseudonymization, we're in aggregation, and our final point would cover is tokenization, which we'll get to. But since we're already speaking about data utility, how do organizations balance the utility of data, its usefulness for analysis, research, or business decisions with the protection of consumer or individual privacy? Like how does that work?
I would say from my experience in working internally with our businesses, it's the collaborative effort. As Kyle mentioned, we view the end goal, or what the use case, what is the outcome for that particular use case. So it's an iterative conversation between the de-identification team, my team, and the business to determine, what the best methods are, and to try to get them to the place that they are trying to get with the particular initiative. So it's a back and forth, and it's a collaborative effort, so that we don't want to apply too stringent of a technique where the data is useless. So we are, in constant communication with them to determine what can we do to this data set? How can we support you, but still maintaining the privacy that is necessary to mitigate against risk?
I think the balancing act characterization is exactly right. Also on the legal side, where organizations weigh, what's the sensitivity of the data, what's the aims that you want to achieve, what are the constraints of the law, and what are the appropriate corresponding de-identification techniques and technical organizational controls that need to be put in place to protect it. And, practically, not a DuckDuckGo specific example, but with, genetic research, you need to maintain that ability to identify individual level data. So it enables participants to withdraw consent and allows researchers to alert patients to incidental findings. But this is, one of the most sensitive areas of data. So the de-identification techniques need to be robust in order to balance against that. So some research organizations have used double pseudonym process to protect data through role-based access permissions, firewall systems, encryptions, and other controls.
Eric, Andreas, Kyle, any other thoughts regarding that balancing act of utility versus individual data utility versus individual privacy?
Yeah, it's always a challenge. Sometimes if you just use raw aggregation, it's kind of natural because your researchers might already know how they want to aggregate the data. So to say, okay, we are interested in demographic groups, age groups, for example. We want the data to be grouped by zip code or by areas, and then you can, by pure aggregation, easily fulfill that, and the resulting quality of the data, if the data set is big enough, can be often good enough. Other techniques like differential privacy, which we're maybe going to talk about as well, where you not only aggregate the data, but also change data values. So add noise to the data, they can be quite problematic. For example, the data by the US Census Bureau, which uses differential privacy, can produce values that are nonsensical. So negative population counts, for example. And as a researcher, if you're working with that kind of data, you need, of course, to take into account the noise that you add to the data when you anonymize. And that can be a bit challenging. I know also in Germany, for example, the statistical Bureau of Statistics uses these kind of techniques, and when you change them, you can mess up, so to say, all of the data pipelines that researchers have built up over the years and that rely on the fact that the data is not, for example, altered in such a way that it can produce nonsensical values. So this can be often a challenge because you need to also educate on how people can actually use this anonymized data and what actual transformations have been done to the data.
And echoing what everyone's mentioned, in the role as in the legal role, you're supporting. You are what is the goal? How can we get there? Recognizing that there may not be, there's a variety of different tools for different situations. Is this the appropriate tool? And does this also reflect the organization's risk appetite? Helping. My job is not to be the office of no. It's kind of to help advise on the risks and potential considerations that may be involved with a particular use case or a particular deployment or how we're structuring something. So the organizations can go in kind of eyes open with a clear understanding of does this make sense for us in this particular instance?
Thank you, Kyle. And we'll jump to tokenization. For our technical folks, you've given great use cases on anonymization, pseudonymization, aggregation, now tokenization. And I personally am curious how tokenization truly differs from pseudonymization, or is tokenization a form of pseudonymization? Can one of our technical folks add some more color?
So I think it can absolutely be a form of it. I think it's more the use cases that make it a little bit of a special case. Tokenized data typically comes up in the context, as you see here, of payment information, of Social Security information, things that are unique identifiers that we have to maintain as unique identifiers, like your credit card number, right? But we don't want the risk of storing that data in our systems anymore. And so we think about payment cards, for example. If you're a merchant and you are collecting that information, your payment gateway, almost always, the company that processes the payment, right, will almost always give you a token back, so that what you store in your database is that token. If that token later gets stolen, it can't be used to process payment because it's unique to your business. And so that tokenization means that I'm no longer storing the information in my systems that are needed. And so the value of my data, the risk to my data is reduced because of that. But it's still a unique identifier, still links, in my system to that customer and the other private information that I have on that customer. It's just that super sensitive information doesn't have to be stored. If you think about the recent national data breach with all the social security numbers, had they been using tokenization, it might have been kind of a non-issue. It's like, everybody's token got stolen. Maybe we don't care as much, but everybody's social security number got stolen. That's major news.
Another use case for tokenization would be sharing data among different organizations or different teams in an effort to maybe build a patient profile, but protecting the data at the same time. There may be identifiable trends or other analytics that would be useful within managing disease processes within a certain geography. But if we're using tokenization, then we get a fuller and a more robust data set around individual patients.
From a legal perspective, and this is why paying attention to the definitions matters, but it can also help reduce risk exposure. I know Eric mentioned the breach earlier of social security numbers. Oftentimes the breach notification obligations may not trigger if the data has been tokenized or pseudonymized. But being mindful of it's not a one size fits all approach, and understanding what jurisdictions you're operating in always matters.
Andreas or Liz, any extra thoughts regarding tokenization?
No, I think that was great. Yeah, from my perspective, the main difference with pseudonymization is mostly organizational, as Eric said, so that a third party, which is also, of course, the case sometimes with pseudonymized data, but that not the same organization holds both parts of the data, and only one organization can, so to say, reverse that. And there's an organizational and a legal separation of these concerns, so to say.
This is great. So since we've covered 4 high-level techniques for de-identification, I'm curious how it works with leadership and leadership's, projects or initiatives or goals to expand the company. How do you sell the de-identification to your organization? Or are we at the point where de-identification is a no-brainer? It's a requirement. It's what we do. So Krista, since you lead a de-identification program, it'd be great to know your perspective. Do you have to sell leadership on de-identification? Does leadership think of de-identification, off the rip, off the cusp? If you can add more color to this.
So we're fortunate that our leadership does value the use of de-identification and understand the implications and how it mitigates against re-identification risk. So that is not, that's not an issue for us. But, just in support of, regulatory compliance and, risk mitigation, and even demonstrating business value and, showing, in the area of customer trust, if they are, if they know that we're that data that we're sharing externally is properly de-identified, then they're more apt to trust us, in the management and handling of their data. But as I mentioned, we're fortunate because management understands.
Before I get any other thoughts on de-identification selling de-identification to leadership. I know we only have 5 minutes left, and goodness, we have so much more content to cover. I mean, HIPAA is coming up next, and a lot of good deep dive content. I didn't know that we're only halfway through our panel questions. So part 2 of this series, look out for the link to register in the next week or so. We'll have part 2 in September. And then we might have to expand to a part 3, because the goal with part 2 was for us to go into day-to-day examples and actually work through de-identification with real world scenarios. However, if we're not through the panel providing you all with content, then we're definitely not ready to get into the scenarios. So with part 2 next month, we will complete the rest of this. We also have HIPAA to cover. We have privacy enhancing technologies as it relates to de-identification, differential privacy, which Andreas has mentioned so many times. So I know he's excited to talk about. We also have de-identification within technology transactions and just the future, the death of cookies. You know, if you've all been paying attention, you saw Google pulled back on, you know, their decision to no longer process third-party cookies. That's not happening anymore. So we have a lot of good stuff to cover, and we will pick up next month. But wanted to flag that because I want to respect all your time. So we have about 3-4 minutes left. So please look out for the registration link, and I will let our technical folks and our legal folks wrap up with this point on selling de-identification to leadership, whether you have to sell it or whether it's a no-brainer. Being that I have DuckDuckGo as speakers on this call, I think that for you all, it's probably a no-brainer if you can add more color regarding how your organization and how your leadership looks at de-identification. Mind you, I've loved DuckDuckGo since I was in law school, so you all are definitely at the forefront of privacy browsing.
Thanks, Tony. Well, like Krista mentioned, it's much easier if your organization is privacy focused. And I think that, you know, establishing tone from the top is very important if you want to sell to leadership where maybe privacy is not front of mind. The framing of how you come at it, I think de-identification needs to be shown as more than a compliance exercise. It's not simply ticking a box. You know, it can deliver value to the business through research, improving business and operational efficiencies, and reducing risk at the same time, and not just simply compliance.
Yes, I totally agree. So as Liz said, yeah, DuckDuckGo, it's an easy sell, so to say, because yeah, everything is geared towards like preserving privacy. So that's yeah, top priority at the company. Other companies I've worked with, sometimes it can be a bit more of a harder sell because it's seen mostly as a liability or a technical complexity. So it takes time, it makes everything more complex. You know, you have like, if you work with pseudonymization, it's you have to change the way your data scientists work, data engineers work with the data, and it's can be very cumbersome. But I think also the mindset there is changing a bit, not only because of the privacy regulations that are becoming more widespread around the world, but also because companies see that data security and security threats are becoming more prevalent. It's often not a question when you lose data, but if you lose data, but when you will lose some data. And if you apply these techniques, then that can drastically reduce the impact of such data theft or data loss on your company. So I think the understanding for this is also getting more widespread, and companies see that there's actually value beyond just complying with the regulation in applying such techniques.
I love the flag to not if, but when you will experience a breach or an incident. And by implementing de-identification and its techniques, it doesn't absolve anything completely. However, it does limit risk, and we all are in the business of limiting risk for our organization and our institutions. Any closing thoughts with our last 60 seconds? Everyone, please come back to join us for part 2 next month. I want to see all 117 of us on this call diving into de-identification. But Eric or Kyle, Krista, Liz, any closing remarks regarding selling de-identification?
I got one quick one. About 20 years ago, data storage got so cheap that companies took the philosophy of let's just store everything and we'll figure out later why we're storing it. And then, of course, as Andreas pointed out, data gets stolen, we start seeing risk, that pendulum swings the other way, and we're like, now we can't store anything. selling de-identification is basically that balanced approach of we can store the data we need to operate the business, and we can do it in a way that's secure and effective.
Love it. Well, on that note, we are at time, everyone. Thanks again for participating. We'll send the link for part 2 out in the next week or so, once I settle with the speakers on a date and a time. Thank you all. It's been extremely informative so far, and we're only halfway into the content. So yeah, thank you for joining us. We look forward to seeing you all again next month. Thank you to our speakers.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.